Hey, greetings, everybody. Paul Rabelais here. Okay, not a topic that's going to take the usual hour that I have for a live stream. I envision it, much less. Maybe have some questions at the end, some chat. So I hope so. The more people we can get involved in the conversation, the better. The more experiences that people share, comments, questions. It's all good. So this live stream, should all your assets be described in your will or trust? And the reason I felt like this topic was appropriate is I think if we cover it'll get some people to act to protect themselves, protect their family, where maybe if they hadn't absorbed this information, they would kind of put things off because they're misunderstanding some things that either need or don't need to be done prior to getting involved in creating the estate plan and getting things in order. So got several key points I want to share as usual. Hey Larry, hey Chelsea, hey Ann, good to see all of you here, and along with Ann's emojis. So always want to encourage you to take advantage of the chat in the right way. You can talk to each other, you can talk to me, you can ask comments, ask questions, make comments, share experiences. We do ask that you keep it positive. Maybe write in the chat like you'd write to your mother, assuming you like your mother. So, all right. What I want to break this down into 4 or 5 parts. Number one, just generally, what do people think when it comes to describing all their assets in their estate planning legal documents? Then I want to talk about the way it actually is in real life. I want to give you some examples, point out a few particulars when it comes to living trusts, and then we'll go to the chat and get going here. So, all right, keep the chat going. I like to see in the activity, whatever that activity might be, as long as it's good, positive. All right, so here's what some people think when it comes to, do you need to describe all of the assets that you own in your will or trust? I say will because some people have a will plan. It's the traditional way to get your legal affairs in order, kind of the old-fashioned way. It's the old last will and testament. I leave my estate, I leave this to this person, I'll leave my estate to my children. You leave everything in your name. When you pass away, your survivors go through the probate process in your state. Use your will, get judges to sign court orders that the will is valid. There's inventories of assets that are filed at the courthouse in the estate's record, and then judges sign court orders ordering that assets be transferred to the appropriate people. That's what I call the will plan. The other one, I've talked about it a lot, is the living trust plan. Very common. When people set up their living trust, the living trust really replaces the will, but people use the living trust because they not only put all those who handles my estate when I die, who gets my trust assets when I die, provisions in their trust, but they also transfer assets to their trust while they're alive, because assets that are in your trust when you pass away, they avoid the court and attorney involved probate process, which many people perceive as expensive, time consuming, and just an all around hassle. And they think that because in most cases it is. Okay, so I'll be talking about the will plan and the trust plan and whether you need to identify all of the assets. But what some people think is that, and this is where hopefully we can trigger some action amongst some people here during this live stream. Some people think that they can't even start the process of getting their estate legal affairs in order until they make this thorough inventory or listing of everything that you own, and you give all of that to an attorney. So then an attorney can start incorporating that information into your estate planning documents. Now, I will say I have hundreds or thousands of attorney colleagues. Everyone has their own way of doing things. Some attorneys, they'll give that prospective client that homework, that sheet or many sheets of paper that you have to fill out, listing all of your family information, all of your assets, answering a bunch of questions. Other attorneys will say, you don't need to prepare anything before we have that conversation. Just come in and we'll get information, get the specifics of family members and assets, as we need it. I'm more of the school of, hey, let's just have that conversation first. And then once we have that conversation and see where we're going, then we can get the information that we need. And the reason I've always been that way for 30 years, not that I'm right or wrong, it's just that if you give someone, not everyone, but if you give someone an opportunity to procrastinate or put things off, as you can imagine, estate planning isn't the topic that most people just jump out of bed and say, let's go, let's get our estate planning done today. It usually, in many cases, if you give someone a reason to procrastinate because estate planning is talking about you're not here anymore, you pass away, your spouse passes away, leaving things to kids. What if your kids predecease you? Just things that you don't have a lot of fun talking about. Not that the estate planning conversation is difficult. We make it fun, but so I like to avoid having our prospective clients do a ton or really do any homework in anticipation of just that first estate planning conversation, which is tell me about your family, tell me what you're trying to accomplish. Let's see if we can start putting a framework together of what your estate plan should look like. And then as we need information, we can get it. But I think some people mistakenly believe that they just can't even contact the lawyer, start the estate planning process until they've made that thorough inventory of everything they have, everything, how is it titled? What is its value? And some people have assets scattered all over the place. So they kind of never wind up making that inventory. And as a result of that, they procrastinate on their estate planning. So some people mistakenly believe they got to have that entire inventory of all the assets before they can even start the estate planning conversation. And generally speaking, that's just false. Let me go over kind of the way it actually is, at least in this man's view. Most people, and I'm making generalities here, most people leave, I'll give you some examples. Their estate planning documents, maybe if they're single, unmarried, and they have children. Most of the estate planning documents say, I leave my estate to my children. I leave my estate to my children equally. I leave my estate to my descendants per stirpes, which is I leave it to my children equally. And if any of my children predecease me, then the child share will go to the child's children. Some people say I leave my estate to my spouse, and if my spouse dies before me, I leave it to my children. Some people say I leave my estate in a trust for my spouse, and my spouse will have certain rights over my surviving spouse's lifetime. And then when my surviving spouse dies, those assets will revert back to my children or my descendants or whoever I'm designating. So all of those estate planning documents that say I leave my estate to my children, I leave my estate to my spouse, I leave my estate in a trust for my spouse and then my children. All of those estate documents, they very rarely, if ever, do they have a listing of your assets. They have these all-encompassing statements so that whatever you own when you die, if you left it to your children, it's going to go to your children, even if you don't own it at the time that you created your estate plan. Now, when it's like that, and it's not always like that, but when it's like that, and it is many times, your specific assets do not get listed in your estate planning legal documents. Now, is it a good idea to have an inventory of those assets? By all means, we provide software, online vaults to our clients where they can have an online storage vault place where all of their asset information can be compiled, all of their estate planning documents get uploaded, lots of decisions that they made are all in their vault, so that there's one central place where if you become incapacitated or when you pass away, those people that you'd want to have immediate access to the information, they've got it all at one click. And that's awesome. But now let me tell you about when it is important to really know what the assets are at the time that you're starting the process of the estate planning. Maybe, because sometimes, not every time, but sometimes people say, you know what, I have, Paul, I have 3 children, and but I want to leave my home to my second child, Jimmy. Jimmy doesn't own a home. He needs a place to live. My other children support me leaving the home to Jimmy. Not that that's a necessity. So what I want to do is I want to leave my home to Jimmy, kind of off the top, and then everything else that I have, we'll divide that up amongst our three children, with Jimmy and my other two children getting a third of everything else. So when you do want to leave a specific asset to a specific person or to specific people, maybe you say, I leave my business to these two people. I leave this vehicle to this person. I leave this account that I have at this bank or at this brokerage firm to be divided among these four people, or to go to this one person. So when you want to leave a specific asset to a specific person, yes, that specific asset needs to be listed in the estate planning legal documents, whether that's the will or living trust, so that it's identifiable, it's clearly identifiable. So there are certain circumstances where when you want to leave a specific asset to specific people, we got to know what that is from the get-go, so we can incorporate that into the legal document. So, but again, you don't have to know, we don't have to list every asset. If you are leaving your home to Jimmy and everything else to your three children equally, while we're creating your will or trust, we don't need to know every specific account number that you have. We don't need to know how much money is in your checking account or in your brokerage account or in your IRA or your Roth IRA. But we do need to accurately describe your home. And quite frankly, while we're on it, if you're going to leave your home to Jimmy, we've got some clarification to do in those estate planning legal documents, because what if there's a mortgage on the home? So does Jimmy inherit it subject to the mortgage, or do other assets of your estate get used to pay off the mortgage when you pass away, so Jimmy gets the home free and clear? What if you sell that home during your lifetime before you die and you go get another home? Does Jimmy get that home? So all that needs to be thought about and incorporated in that specific bequest of the home to Jimmy. What if you sell your home and you don't buy another home? Does Jimmy get some money so he can go out and buy a home? So those are some secondary decisions that need to be made when you do leave a specific asset to a specific person. What if Jimmy dies before you? Who's going to get the home? Does it go to Jimmy's kids, or does it go equally, descendants per stirpes kind of thing? So, on the thought of, do you need to describe all of your assets in your will or trust? Generally, the answer is no, unless you want to specifically bequeath certain assets or assets to certain people. But sometimes when I read wills or trusts of that were written by others, and I see some kind of redundancy. It might say, somebody with three children might say, I leave my home to my three children, and I leave my bank account to my three children, and I leave the rest of my estate to my three children equally. So when I see that, I'm like, well, why did they even specifically list, the home and the bank account to the three children, when the way it was worded, even if they hadn't listed it, the home and the bank account would have gone exactly the same way, and even if they didn't specify that asset in the document. So while my point on this is, while it is important to have an inventory of assets, some people pull out the sheet of paper and write down everything they own. Some people make an Excel spreadsheet. Some people use an online vault. Our clients do. While all that's really, really helpful, it's that information typically does not go in the four corners of the will or living trust that you may have. And yes, if you have a living trust, it is important, once you sign your trust, make it official, then it's really important that those assets of yours get titled correctly. I'll come back to the living trust plan more so here in a moment. Okay. Now, some people mistakenly believe, I don't want to do my will just yet, or I don't want to do my trust just yet, because I think in a couple of years I'm gonna sell my house. I'm gonna downsize. I'm gonna move to another state. So again, it's just a false assumption if you think that you shouldn't get your estate in order, because in the future you may acquire or dispose of assets. Many times when people do have an estate plan in place and they do acquire or dispose of assets in the future, no changes need to be made. I had a gentleman, he wanted to travel hours, and most of our meetings are by Zoom anyway, but he was an old man and he didn't know how to use Zoom. So he wanted to travel hours because we had created his living trust plan several years ago. And he's like, Paul, I need to come see you. I need to make a bunch of changes. And I was like, don't come see me yet, because a lot of people who who think they need to make a bunch of changes to their estate plan, they really don't. And so I said, well, I tell you what, we were talking, and I said, tell me a little bit about what some of those changes are that you think you need to make. So that way, if we do have a conversation about it, I'll be prepared. And he was a gentleman that had several different pieces of real estate, and he had several brokerage accounts. And he was like, well, I sold this property, Paul, so I need to make a change for that. I sold this other property, Paul. I need to make a change for that. I gave this property to my son. And what I also did was I moved my investments from one brokerage firm to another brokerage firm. And really, his estate, while he had lots of assets, was relatively simple. His wife has passed away, so he was leaving everything to his children. And I was like, okay, so you sold all these properties. Well, we don't need to make any changes as a result of that. We didn't list those properties in your trust. Yes, they were owned by your trust when you sold them, but the fact that your trust sold them doesn't mean we need to update your estate plan, unless for some reason you want to change who's going to be the trustee when you pass away, or change that distribution schedule. Likewise, with moving your money from one brokerage account to another brokerage firm, I was like, yeah, your old brokerage account was titled in the name of your trust. Is your new brokerage account titled in the name of your trust? He was like, yeah. We made sure when we moved it to this brokerage firm, ABC brokerage firm, and that account's titled in my trust. I was like, well, we don't list all of those assets in your trust or in your portfolio will. So he ultimately realized there was no need to change anything, and so that was awesome. Really eliminated a lot of time on his part and mine. So a lot of people are under this mistaken assumption that they'll need to change things. In fact, well, let me get to that in a minute. So let me give you a couple of examples. Let me first talk about the typical kind of will plan and the idea of listing the assets in the will. Then I'll get into the living trust plan, and we'll have to talk about the funding on that as well. So many, many wills out there, single people. I leave all of my assets, or I leave my estate to my spouse, or I leave my estate to my children, or I leave my estate to my spouse. And if my spouse predeceases me, I leave my estate to my children. Those are the provisions in the wills. Or I leave my estate to a testamentary trust for the benefit of my spouse. My spouse will be the trustee. My spouse will get the income. If my spouse needs to use the principal for my spouse's health, education, maintenance, and support after I pass away, no problem there. But when my spouse dies, assets revert back to my children. No, the assets don't get listed in the will. If you buy something new, no big deal. If you receive an inheritance, no big deal, as long as you want the inheritance to go the same way that all your other assets will go when you pass away. There's no reason to update or change anything. So now, again, there is a reason to list specific assets in your will. If you want a specific asset to go to a certain people, I leave my house to Jimmy. I leave everything else to my children equally. I leave my car to my grandchild. I leave everything else to my children equally. I leave $20,000 to each of my grandchildren. I leave the rest of my estate to my 3 children equally. Even then, you don't have to, an asset isn't listed in the will if you're making a cash bequest to someone and then leaving the remainder perhaps to your children, to your spouse, or to a trust for your spouse and children. So, and then on top of that, many people use TOD and POD designations to provide for brokerage accounts, stock accounts, bank accounts, and credit unions with POD designations. So that's stuff when you can and do take advantage of TOD and POD designations, the will or trust has nothing to do with that. When you pass away, that account, if it's a brokerage account or a stock account or a bank or credit union account, that financial institution will just pay those beneficiaries directly, kind of outside of whatever the will or trust might say. I will say, if you do want to leave things to charity, maybe you have a will plan, you've got 2 kids, sure, you want to take care of your kids, but you have this charitable intent where you'd like to leave something. Maybe it's not a significant amount. Maybe you want the bulk of what you have to go to your children. Maybe you want 90% of what you have to go to your children, but you'd like to leave something to charity. Again, while I'm on it, the most tax advantageous way to leave something to charity, but the net after all taxes have been paid, the net to the family is greater, is by naming the charity as a beneficiary of, perhaps if you have it, your traditional IRA or your traditional 401k, because generally speaking, whoever receives your traditional IRA, they got to pay income tax on it. And whoever receives the other assets of yours, your house, your bank account, your stock account, they don't pay income tax on that. So the idea there, tax efficiency, if you want to leave something to charity, leave it to them from your traditional IRA, because the charity doesn't pay income tax when it receives all or a portion of your traditional IRA. And then leave the assets that your children can inherit income tax free, leave all of those assets to your children. So there's just a little issue there when you want to leave something to charity and you want to try to do it all tax efficiently. Now, on the note of whether you should leave something, whether you have to describe all of your assets and you have a living trust plan, again, very common. Many people, Fred Flintstone may set up the Fred Flintstone Living Trust, and Fred's the trustee, and Fred can do whatever he wants with the trust assets while he's alive. But when Fred dies, the trust goes on, perhaps for his wife Wilma and his child Pebbles and whoever. So with a living trust, there is more of a reason to do some homework and create that inventory of assets. Because when you create a living trust, to make the living trust work so that the probate is avoided, you not only have to create your living trust, but you have to transfer title of those, what we call probate assets. You have to transfer title of those assets to your trust during your lifetime. You don't have to transfer title of your IRA or your life insurance policy. Those accounts have designated beneficiaries, and those are what's called non-probate assets. But if you go the living trust plan route, which my guess is well over 50% of America these days, when they're creating their estate plan, is creating a living trust, because if you don't, and you either, if you die with assets in your name, whether you have a will or not, there's going to be a probate process, and that's where the government gets involved. And so there's delay and expense and hassle. Most people want to avoid that, so they create their living trust. Very, very common. It's what we do in our law firm. Most of our work is helping people create, customize, and fund their living trust. But there is more of an, maybe urgency is the right word, to have an excellent inventory of assets when you create your living trust, because there's a process of discussing how your living trust should be customized. And there's the process of preparing it and reviewing it for accuracy before it's made official. And then there's the process of making it official, getting it signed and notarized and witnessed in accordance with all the rules. But once you make your living trust official and you create it and you sign it, then there's a process of funding your living trust, transferring the home from Fred Flintstone to Fred Flintstone as trustee of the Fred Flintstone Trust, transferring the brokerage account from say that 5 times fast, Fred Flintstone to Fred Flintstone as trustee of the Fred Flintstone Trust. Because again, avoiding probate involves creating your trust and transferring title of assets to it. So when you create that will plan, it's really not as important. Great to have a full inventory of assets, but really that inventory of assets is needed when you pass away, once you start going through the probate process, and the court system needs an inventory of assets after you die so that a judge can sign an order ordering that all those inventoried and listed assets can be transferred to the right people pursuant to that court order. But with a living trust, the key is to have that inventory now, and you're kind of doing some work ahead of time, transferring assets to your living trust while you're alive, so that when you die, all that court stuff is unnecessary. So I'd say, yeah, a little more of an urgency and a little more homework to do with your living trust. And you might be saying, well, why would I want to have something that requires that I do more homework? Well, you're doing a little bit of effort now to save your survivors lots of effort in the future now. Kind of reminds me of was it the Midas the muffler commercials when I was growing up, probably 40 years ago? It was, you can pay me now or you can pay me later. That's a little bit how the probate environment works. You can do a little bit of work now, set up that living trust to avoid the probate in the future, or you can either leave all of your assets in your name, have no will, or have a will. But in most circumstances, you're going to pay the piper a little bit more when you pass away, or at least your estate will or your survivor's will. Okay, and yes, are there exceptions to all of those things? Yes. Are there some probates that are really simple? Certainly there are. Are there some that are a nightmare? Sure there are. Just, but generally speaking, there's just more effort and time and expense and hassle when the family's got to go through the probate. So like most people say, hey, if we can avoid it, make it easy for people, let's do it. All right, so bottom line here on this one is, no one should really put off estate planning because they either don't know exactly what they own, they haven't made that inventory, or they shouldn't put off estate planning because they feel like they're going to acquire assets in the future or dispose of assets in the future. I've talked to a lot of people who have said that they're scared about legal fees for changes to their estate plan. And so they're like, Paul, and look, we're really transparent about legal expense when people set up, change, whatever. Because consumers, they deserve to know, what they're getting into, which is fine. And so, but I think a lot of the public is really scared, and they're trying to take some life actions to maybe save a few dollars in the future. So they're like, I don't know if I want to do this estate plan now because I'm gonna move in 6 months. I'm gonna retire in a year and move my money to a different place, or I may go buy a vacation home in a couple of years, and so I don't want to have to amend all my estate planning documents, every time I do something like that. But the reality is, yeah, you create your estate plan, and the likelihood that you'll need to change, you'll need to hire a lawyer and incur legal expense to change your legal documents because you acquired assets or disposed of assets after you created an estate plan. The likelihood that you'll have to incur legal fees to do that is very minimal. The only reason you'd have to incur, because we tell, like we tell everyone, if you buy a new property in the future, let's say you do have a living trust plan, and 2 years later you buy a new piece of property, buy it in the name of the trust. We're not going to list that piece of property in the trust legal instrument. But yes, it is important that when you acquire it in the name of the trust. So it'll be subject to the trust terms when you pass away. If you open a new brokerage account, open it in the name of the trust. The only reason you'd need to change your estate legal documents is if you want to specify particularly who's going to get that asset when you pass away. But if it's just one of those residuary assets that's going to go according to your, residuary clause in your will or trust, we don't need to change your estate planning legal documents. Okay. So don't put off estate planning because you might acquire or dispose of assets in the future. Yes, start your estate planning with an inventory of assets, particularly if you want to specifically bequeath a specific asset to a specific person. Yes, it's great to have an inventory of assets if you're creating a living trust so that for titling purposes, whoever's assisting with you, if someone is assisting you in the creation of your trust and the implementation of it, you'll get that kind of hand holding or guidance when funding your trust after you make it official. And I will mention one other point. If you've accumulated some significant assets and you're in that, upper level of wealth, then when you create your estate plan, I would say it is important to have an inventory of the assets. Not only what assets do you own, but what is the fair market value of those assets? Because as I've mentioned on many live streams here, we have a 40% federal estate tax. Right now, large estate tax exemption, first $13.61 million of assets that somebody has when they die is exempt from the roughly 40% federal estate tax. A few states have their own state death tax and with much smaller exemptions. So for purposes of sometimes making decisions to help the family avoid estate tax, federal or state, estate or inheritance tax, an inventory is helpful. But again, the assets typically don't get listed in the four corners of the will or the trust. All right. So with that in mind, my kind of bottom line here is don't let the fact that you're not sure exactly what you own or the fact that what you own is going to change in the future, that should have no bearing on the fact that you should put off creating your estate plan, providing for your family, putting the right people in charge, or even specifying how certain assets should go to certain people. All right, let's bump over. Hey, Larry. Hey, Ann made it on time. I'm impressed with your punctuality, Ann. Fantastic. Larry's always punctual. Ray saying hello. Hello, Ray. Larry saying hey to Ann. Gotta like it. Been to 40 countries is saying hi. Kim, for someone is okay. All right. So your Kim question, not necessarily, well, kind of on point. For someone who wants to get Medicaid, what trust should you do to put the assets is what Kim is asking. So I'm going to read between the lines. I'm guessing you're asking if someone wants to qualify for long-term care Medicaid in the future because they may go into a nursing home, skilled nursing facility, and they don't want to have to private pay. They want to protect those assets and have the government or Medicaid cover that long-term care expense, which based on whatever state you're in may be anywhere from $7,000 to $13,000 less or more per month. So when it comes to Medicaid planning, which I didn't address up until now, really, really important there to have an inventory of exactly what you own and exactly what it's worth, because your potential Medicaid qualification is based kind of to the penny on what you own. If a single person applies for Medicaid, if they have more than $2,000, they won't be eligible. $3,000 maybe in some states. Married couples, $3,000. There's the community spouse resource allowance. There's income limits. So I haven't talked, this really wasn't focused on Medicaid planning, but if you are engaging in this kind of pre-planning for Medicaid, and again, it's all about transferring assets out of your name, ideally at least 5 years before you enter a nursing home. And those some people mistakenly believe, well, if you put your assets in a revocable trust, that doesn't do you any good. If you put your assets in an irrevocable trust, you're home free. Well, it's not just that. It has to be a very particular type of irrevocable trust that meets the specifications of your state's Medicaid rules. So got to get it right. So, but anyway, hopefully that helps. Richard's saying, hi, Mom. So maybe, Richard, your mom is watching. I don't know. People get in their feelings when you talk about them passing away. True. I talked about that procrastination. Hi, Paul. Hi, Hongen. I'm not even going to try to pronounce it, but I've seen you on a couple of these. Always good to have you. I'll just call you Hong. If you on Medicaid, you can only 2,000 less. There are no other tools, right? So, well, the whole trying to position yourself to qualify for long-term care or Medicaid, if you go into a nursing home, that's a 2-hour live stream right there. So I don't want to say yes or no. Yes, you talked about one of the rules for a single person. They have to have less than $2,000 of countable resources. Perhaps they can own other exempt assets. There's a lot more to that. And really, this isn't a Medicaid eligibility live stream, but good question. But your assets and low, I don't know what it entails. Okay, Richard, if a brokerage account is in a living trust, will the cost basis flow through to the beneficiary? I get that question a lot. So yeah, if you have your brokerage account, you've got assets that have appreciated, stocks, bonds, mutual funds, and you transfer that into your typical revocable living trust that many, many, many Americans have for the purpose of avoiding probate, will the cost basis flow through to the beneficiary? Yeah. So if you have that revocable living trust that's designed to avoid probate, the key here is because you have transferred your assets to a revocable living trust, you haven't removed those assets you've removed them from your estate for probate purposes, but because you can revoke your trust and do whatever you want to with those trust assets, those assets are still in your estate for federal estate tax purposes, which in your case may be a good thing, because as long as assets are in your estate for federal estate tax purposes, yes, they get the step up in basis. So the living trust, whether assets are in your name when you die or in your revocable living trust, they get the same capital gains tax step up in basis. That doesn't help or hurt that step up in basis when you transfer assets to a revocable living trust. The assets have to be out of someone's name for 5 years. Hard, Paul can explain. Yeah, I can explain. I'm just not going to explain in this live stream, but perhaps in another one. I've done a couple of them. Maybe you can search the YouTube channel for some of the Medicaid eligibility live streams that I've done in the past. And I've helped a lot of people, position themselves for that over the years. Lacey, another name I see familiar with the hand clap. And what is that? Oh yeah, you have the emojis there. Clapping, and I've been recommended to check out as soon as so knowledgeable. Yeah, Lacey, flattery will get you everywhere. So thank you for that. Can you include a letter each year that lists assets from Hanico? I thought I might get some questions, and maybe I still will, on what do you do with the personal items? You have your diamond engagement ring, you have your china, you have your Mickey Mouse collection. And so some people do specify that in the legal documents. I want my diamond engagement ring to go to my granddaughter, Tina, and I want the rest of my estate to go to my 3 children. Some people do that outside of their estate planning legal documents, either formally or informally, perhaps through some tangible personal property memorandum that your state allows, or maybe just informally of making a list or writing a letter. Maybe you're referring to that, Hanico, about how you want to leave, non-titled personal items. There's a couple of different options there. Some more formal, some less formal, some more official, some less official. Let's see. DB Douglas, single, no kids, no close, we're not sure about who should be trustee. Yeah. So we've had, a lot of people in your circumstances, they just don't have anybody. And so, but you have to designate somebody. Could be an individual, could be a corporate trustee that could handle things. And so I've done some videos and live streams on selecting an individual versus selecting a corporate trustee. Maybe some of that could help. Thanks, Catherine Henderson, for your good information comment. Fantastic. There you go. Hanico's telling DB you can appoint a professional company. Yep, sure can. Those are you got to get past the fact that they're going to charge fees, but generally speaking, they do a good job. They've had to put up a lot of capital to the state to be able to even position themselves as a trust company and offer services as a trustee. So a lot of protection there for the beneficiaries from a corporate trustee doing something wrong. Let's see. Not exactly trusting of attorneys is what DB says. Okay. Yep. And probably with good reason. All right. What about a friend? Good point there. Thinking that's good. I'm glad to see y'all talking back and forth to each other. In fact, I got a note about that in a minute. Smash the like button. Yeah, we'd love to see you like the button. We've got 46 here. Love some more. But again, hang on here. I got some good stuff to tell you here in a second. Something brand new I want to share with you. Just hang on for a couple of minutes as we get through these things. Question, please, regarding living trust. Can you list again those items or accounts that are taxable to a beneficiary? Okay, good question. Kind of a broad question, Lacey, but let me give it my best shot. Generally speaking, an inheritance is income tax free. If you leave your bank account to heirs, they'll get it income tax free. Checking, savings, CDs. You leave 100 shares of stock to someone. Yes, they don't pay income tax on the value of that when they receive it, and they get the step up in basis, which is a separate capital gains tax issue. You leave a house worth $400,000 to someone. They don't pay income tax on that $400,000. Yes, if they sell it after they inherit it and they get more than $400,000 from the sale, they'll pay capital gains tax on the appreciation from the date you passed away. That's, so, but no income tax. Now, life insurance, if you own life insurance, you leave it to someone, they don't pay income tax on it. But, same with Roth IRAs. But the main asset that heirs or beneficiaries must pay income tax on, and there's really nothing you can do about it, is when you name individuals as beneficiaries of your traditional IRA or your 401k, or let's call it your traditional 401k, or 403b or SEP IRA, all those retirement accounts where the money went in prior to income tax being paid. Well, whoever gets distributions from those accounts, whether it's you, your spouse, your children, other relatives, they'll have to include those distributions as ordinary income. We've done some live streams on that. So good question. Let's see here. Bradley says goat. If it says what I think you're meaning, fantastic. I've never really thought of GOAT, which to me is greatest of all time. Always think about that in the sports context. Michael Jordan's the GOAT. Probably Tom Brady's the GOAT. Maybe Babe Ruth was the GOAT. I don't know, but you put GOAT on an estate planning live stream, so that's cool. All right, thoughts on real estate outside the U.S. Put in the U.S. trust? Probably not. If real estate outside the U.S. is going to be governed by that country's rules, so you've got to deal with whatever issues are involved in that country. In a living trust, is it important to list separately all personal property? Like where does it go or under what section? It usually just falls under that. If you don't list any of that stuff out, those are just assets. If your residuary clause in your trust says, I leave everything else that I own to my 3 children, that would include all your jewelry, your musical instruments. Now, if you do want to specify that the jewelry and musical instruments go to specific people, you can either list that in your trust, or if your state allows it, you do what's called a tangible personal property memorandum, which you can change and add to from time to time without going through the formal route of changing your trust. State-specific issue there. I'm trying to educate my parents on setting budget if they don't believe it's necessary. Maybe you ought to watch a live stream with them. Maybe that'll help. I don't know. You're welcome. And what do we include in Exhibit A of the trust? Yeah, a lot of people. Now, here's the deal with the Exhibit A of the trust. Many people do list in an Exhibit A of the trust. They list those assets that are in the trust. And I know California has a special provision. I'll get to California in a second. But a lot of people mistakenly believe that if they list, their home and their brokerage account and their bank account and all these assets on that Exhibit A of their trust, they mistakenly assume that they've transferred the assets to the trust. But listing them on Exhibit A doesn't transfer title of those assets to the trust. You've got to go through the formal process of filling out the appropriate, deed to transfer the property to the trust, or on the financial institution's records. Those, the financial institution needs to show that it's listed, that the trust is the owner. And I know in California, there's this particular petition that where if you listed it on Exhibit A, it could be deemed as being transferred to the trust. But just be careful with your Exhibit A's. Don't make the false assumption that it's been transferred to your trust because it's on Exhibit A. Great question there. So better to have a private nurse at home. That's again a nursing home question. That's a handful there, but probably so. It probably is better to have a nurse at home. Let's see, but they are expensive. Yeah, so that's Hannako talking about the nurse at home. Do you only work in Florida? We work in all the just about all the states. If you go look in the description of the video, you'll get a link to to a questionnaire that you can fill out. I think in the questionnaire it lists the 5 or 6 states where we can't do business because of the particular rules of professional responsibility. But if you're in one of those 45 states, what happens is you work with our office. We have our co-counsel in the particular state that participates, but you work with us and we get it done. All right, let's see. Can you talk about Tennessee trust? No income tax, but trustee has to live in Tennessee. Can I make my son the co-trustee? Since perhaps, yep. So he lives there, maybe, but you don't. So I guess is what you're saying. You don't live in Tennessee. Your son does. Can he be a co-trustee? And can you have a Tennessee trust? We'd have to talk about that one. Generally have people create their trust subject to the state law of where they are domiciled, but we can talk about that. You have a son who might be a co-trustee. Hello, Domingo. That's a new name. Let's see. I'm going to skip for now the Hannako discussion. That seems to be all about nursing homes and nursing home care. If stock or bank account, Chelsea, is worth $1,000 when decedent dies, but when probate is finished and assets are transferred, what is tax consequence? All right, so when you say what are the tax consequences, and maybe you're talking like a bank savings account that could accrue lots of interest. So if you inherit a bank account and it was $1,000 when the person died, but because it took a while for the probate process to complete, and that bank account produced some interest, and you wind up getting $1,500 or $1,100, somebody, probably the estate, while the probate process is going on, is having to pay income tax on the interest that $1,000 account produced. So the estate or the trust will pay income tax on that income from the time that the person dies on income produced until that asset is distributed to the beneficiary. And then once you get your $1,500, as that account starts producing some interest, you'll pay income tax on that interest, generally speaking. All right, what is a sweeping will? Can't say that I've ever used that, heard that term. Automatically sweeps all of your assets. It's typically referred to as a pour-over will. Maybe somebody has used the term sweeping will. I'm not going to say it. Sweeps is kind of the same as pours over, same kind of action there. So yeah, sweeping will. I think you were never heard that term, but the more popular term, commonly used term, is that pour-over will. It's really just a will, but in the terms of the will, it says if I don't die with any assets that are still in my name, I leave those assets to my living trust. Or the slang term is, I'm pouring those. And so the probate is necessary to transfer those assets that are still in your name when you die to your trust. That's why it's so important that you do fund your trust, transfer those assets during your lifetime, so the pour-over will doesn't even have to be used. All right, let's see. Special needs and 401k, 10 years, does that change because it's special needs? So there are some exceptions. That's a good question. And we'd have to look at those definitions. But normally, if you name a child as a beneficiary of an IRA, traditional IRA, then they've got to take those distributions and it's got to be paid out to them within 10 years after you die. There's some exceptions for chronically ill and disabled children where and there's a couple of other exceptions as well. But I do recall the chronically ill and disabled exceptions. Those people are what's referred to as, is it qualified designated beneficiaries? And they do get to use their life expectancy instead of the 10-year rule. So there's some special rules there. Okay, how often should I review the revocable trust with an attorney? It's not necessarily how often. That's one factor, but have your circumstances changed? Did you get married? Did you get divorced? Did your net worth change significantly? Did you change your mind about who you want to inherit or who you want to handle this when you pass away? Maybe very generally, maybe every year you should look at it, maybe every 3, maybe 5 years. But most of the time, people don't need to change things unless they change their mind about how they want things left behind. All right. Went to assisted living, Maryland, $8,000 a month. Yep. All more of that long-term care talk. All right. So last thing, I want to kind of make a kind of a big announcement. Let me just, and this is something that I've been working on really for about a year now. I've been dabbling with it. I haven't mentioned it, but what I have done is I've done these live streams. It's kind of created a little bit of community with the Larrys and the Anns and everybody else who's been involved in these. So it's not required that you do this, but I am kind of looking for my first few members in a new. I'm launching a private and online kind of estate planning community network where you can interact and engage and collaborate with me and with other people who are like you. So we'll have some live streaming events where kind of a little bit like this, but better. Conversations and messaging will keep going. Before, during, and after these estate planning events, you can connect with other individuals who are sharing similar estate planning concerns. There's a supportive network for discussing and resolving concerns. There's nothing like that on the internet from no kind of estate planning community. And so we're going to build that together. As a result, you'll develop your own strategies to protect your family's future, ensuring your wishes are carried out for generations. So if you want to take a look at and even try out this estate planning community, the first time I've ever mentioned it, but launching it really kind of right now. And I'm going to add resources, checklists, forms, all related to estate planning, teaching material that you'll have access to, 24/7, 365. So it's called the Impactful Inheritance Community. If you want to check it out, you can check out the community, and it's free for 30 days. If you just want to check it out, you can click the link in the description and then click on that link for the Impactful Inheritance Community. I'm going to be gradually focusing my client time from YouTube to our much more interactive and much more powerful and many more resources Impactful Inheritance Community. I'm not saying bye-bye to YouTube by any stretch. So feel free to check that out. Looking for a few members. If you do want to try out the 30 days, I'll see you on there. I'll probably direct message you myself. And first thing that you can do is you can fill out your kind of introductory material, introduce yourself, and we'll be off and running. So just wanted to mention that. Y'all have a great evening. We'll see you both tomorrow and the next day for a couple of more live streams. I'm really excited about both of those, especially the one on Tuesday, the 23rd. Y'all have a great evening, and we'll see you next time.